Hey, what y'all doing out there? What y'all doing out there? What y'all doing out there? Hey, you already know who it is. B was Mr. Power Move 06. Hey, today we live back in the building, and we're gonna be having some training today. We're gonna be talking about the complex trust. Yes, the complex trust fund. Hey, this is gonna be brought to you by my my actual guy. Hold on one moment, y'all. Hey, we're gonna be having some training today. We're gonna be talking about trust my assets with the complex trust with Make Wealth Real Financial. Okay. So we're gonna get right off into this thing. Hold up, y'all, one moment. Close that craziness out. Come back into that. All right, let me take this bar off and let me know if y'all can see my string and all that good stuff. All right, so right there, I think. Yeah, there we go. So, hey, I'm gonna play an awesome video. Hey, I want y'all to enjoy this training. This is some wealth tips from Trust My Asset, Make Wealth Real. And of course, I'm your host. But hey, we're gonna chime into an awesome information with this Trust My Asset with Mr. Roger Grant. So once y'all can view my stream, let me know, and we're gonna get right off into this conversation. Okay. So let me know you see my stream and enjoy this video. It's gonna be some awesome training. Okay.
Greetings, MWR family, and welcome to our Structure My Legacy training, where today you're going to learn how to reduce your tax rate to 5% or less legally without scrounging for write-offs. This is going to be a bit of a unique training. It's going to be a bit interactive, so I want you to grab a notepad and make sure you have access to the internet, because there's some things I'm going to want you to Google for yourselves as we move forward. What I'm sharing with you today is not a new or novel idea. It's not illegal, and the elite have been using this system for over 100 years, since 1913 when the IRS was created. We're going to show you that this is not something you're going to have to litigate, because it has been litigated. We're going to give you a bunch of legal precedents to show you that this is not new, it is not novel, and the courts have spoken on this matter. As we go through this information, you're probably going to ask yourself this question: why haven't I heard this before? That's a common question that everybody asks, including myself. And the fact of the matter is, it's probably because your CPA or your attorney just don't know, and it's not their fault. It's actually by design, and we will discuss that later. All of the tax forms that you'll need after you apply what I share with you today are available directly on the irs.gov website. We advise 100% full disclosure. When you know the law and the tax codes, there's no need to hide anything, so always file your taxes and report your income. Let me introduce you all to the 1041 tax form. When the IRS was created in 1913, they had two tax forms that they created. One was a 1040, which everybody knows and has filed. The other was a 1041, which is a U.S. income tax return for estates and trust. If you have a complicated tax situation, you know a 1040 tax form can be extremely long. This tax form is 2 pages, has been 2 pages since the beginning, and probably will never cease to be 2 pages. But this is the tax form that allows us to do what we do. So you guys will all become very familiar with this particular tax form. When we're speaking of taxes, what we're really ultimately talking about is social capital, right? The government taking in money from the people and supposedly using that money for different services that need to be rendered. That is what we call involuntary social capital. What we're going to talk about today is going to be voluntary social capital, where through your own private family foundation, we get to disperse funds to communities and programs and nonprofits and benefit our society the way we see fit, versus expecting the government to know how to do that for us. During this training, you're going to learn how to reduce your taxes to 5% or less with full disclosure and filing all of the proper tax paperwork. You'll learn how to protect your assets from lawsuits, divorce, or any of life's unforeseen events that may cost you money. You'll learn how to leave a bulletproof inheritance and a legacy without worrying about probate, lawyers' fees, the inheritance tax, death tax, or any other of what we like to call eroding factors. You're going to learn how to eliminate the potential for an IRS audit. Yes, I said eliminate the potential for an IRS audit by being in the proper jurisdiction of law. So ask yourself if this sounds like you. You're making good money, but you're struggling to keep it, and getting ahead is a challenge. Are you in a place where you're using the majority of your profits to purchase things or acquire things that will allow you to have tax write-offs? Are you concerned about how to leave your estate, business, and legacy to the people that you love without outside interference? Do you dread gathering all of your receipts and documents to bring to your CPA so you can itemize and complete all of the complicated tax forms? Yes, MWR is helping with that process, so it's less complicated, but it's still a process that most are probably still going through at this point in time. Are you in a place where you want to have more control over your hard-earned money instead of the government controlling and dictating to you what you do with your own money? So if those questions resonated with you, then you have to recognize that there is a problem. And the problem is there's two sets of financial information in this country. If you make a certain amount of money, you're privy to one set of information. Doesn't necessarily mean that you're going to get it, but you have a much better shot. Everything else is offered to the public, kind of like the 1041 tax form. It's been around as long as the IRS has been around. It's been here just as long as the 1040 tax form, but most people have never heard of the 1041 tax form, and even less have filed the 1041 tax form. Once you understand the difference between these two sets of financial information, you'll keep more of your profits that you've worked so hard for. You'll reach your financial goals much, much faster. You'll then be in a position to create generational wealth for your children and grandchildren. You'll be able to have peace of mind that everything that you spent your life building isn't wiped out over one unfortunate incident. You won't lose sleep anymore worrying about tax season or tax audits, and wouldn't that be refreshing? So before we go any further, let me introduce myself. My name is Roger Grant, and I'm the head of the MWR Trust Division. I've spent the majority of my life in the financial services, spent a decade straight in the mortgage business until the mortgage meltdown, off and on about 10 years in the insurance business, and have become accustomed to making multiple six figures a year. Now, I mentioned to you guys that there are two sets of financial information in this country. I want to share with you how not having the right financial information affected me personally and why I'm so passionate about what it is that I do. So when I was 28 years old, I started off in the mortgage business. In my first year, I made about $60,000. And I thought that was pretty good because I'd never made that amount of money in my life. So I'm thinking, okay, let's see what we can do with this. The next year, I tripled that amount of money, and the government proceeded to beat me over the head for $50,000. Now, I'm sitting in my CPA's office when he's delivering me this message, and he's telling me, Roger, you're in your business, you have minimal expenses, you don't own a home, you don't have any children, you don't have enough write-offs and deductions, right? And he said they're going to keep cracking you over the head each year until you figure out a way to have some write-offs and deductions. Now, at this point in time, my child, my first child, my only child actually, was in the womb, and she was born the next day because this meeting sent her mother into labor, and she was born the next morning. So what my CPA told me caused me to go out and to buy a $650,000 5-bedroom home. Now, Mind you, I didn't have any children, so I didn't necessarily need a $650,000 5-bedroom home. What I did need was that $3,500 a month mortgage payment as a write-off, as a deduction. Shortly after moving into my home, my CPA also put me into a large insurance policy. It was $1,200 a month. And the reason he did that is because corporate income, I had a C Corp at the time, corporate income, the first $50,000 of corporate income is only taxed at 15%. So this life insurance policy, it was a variable universal life insurance policy, allowed me to put away $33,000 a year, slightly taxed money, only taxed at 15%, on top of the $30,000 I could put at that time into my SEP IRA. So it gave me another place to put away money that was minimally taxed, putting it out of the reach of the IRS, right? Now, there was another loophole in the law at the time that I took advantage of as well. Actually, I believe that loophole in the law still exists today. So here's what happened. About a year after all of this happened, I had a custody battle for my daughter. And the first year of this custody battle cost me about $128,000. So I couldn't afford to pay my quarterly payments to the IRS, and I knew at the end of the year they were going to crush me. So there's this loophole in the law that allowed you, business owners, if you buy a 6,000-pound piece of equipment, which was intended for farmers to incentivize them to buy tractors and whatnot, but any business owner who buys a 6,000-pound piece of equipment could write the whole thing off that year. So what I did was I went out and loaded up a $72,000 Cadillac Escalade. Now, folks, I didn't need a Cadillac Escalade. I already had a Cadillac Escalade and didn't need another one. What I needed was somewhere else to put money so the IRS wouldn't crush me for not paying my quarterly taxes. So what we had here was the house, the life insurance, and a vehicle, none of which I necessarily needed at the size or the amount that I got them. But this is the advice that I was given to prevent the IRS from taking money from me. So to make a long story short, I was spending $72,000 a year to keep the IRS from taking $50,000 a year from me. So I did that for the next 8 years. Got the IRS situation straightened out, got full custody of my daughter, was paying the $72,000 to minimize my taxes, and then the mortgage meltdown came. And because I was dealing with all of these financial situations, when the mortgage meltdown came, I really had nothing left over to survive it. And so I was a casualty of the mortgage meltdown. Why? Because I did not know that there was a better way. So given that there are two sets of financial information in this country, then that means there are two paths financially in this country, the public path and the private path. Most of you are probably familiar with this quote from Nelson Rockefeller, which is John D. Rockefeller's grandson and the former vice president of the United States of America. He said the key to success is to own nothing but control everything. Now, I'm guessing that most of you don't know exactly what that means or how to pull that off. But the only way that you can have full control over assets and zero liabilities of ownership is to be the trustee in a true trust contract. And the reason Rockefeller said what he said is because there are liabilities to ownership. Anything that you own can be taxed to you and taken from you. So let's take a quick look at the public path versus the private path and how Rockefeller's quote applies to these two different paths. We're going to take a look at a business that is fairly profitable, grossing $500,000 in income, $300,000 in expenses, and $200,000 of taxable liability. On the public path, most businesses are set up as LLCs or S corps. So on an LLC, the profits are passed through to the members, and on an S corp, the profits are passed through to the owners. So this $200,000 of tax liability is going to be passed through to the owner. So let's say this is a single member LLC. That means the owner has $200,000 that he's going to take in on a K1 and pay personal income tax. He's going to have the tax liability of that $200,000. And with write-offs and whatnot, he'll probably pay somewhere in the range of $35,000 to $50,000 in taxes conservatively. On the private path, here's how we would handle that situation. We would change that single member LLC into a multi-member LLC. We would have the owner of the company add a business trust as a partner. And now, instead of that $200,000 going on a K1 to the owner of the company, now the $200,000 will go on a K1 to the business trust. Now, the business trust has the ability to pay the taxes on that $200,000, or it can disperse it out to a beneficiary. We don't want to pay taxes on the $200,000, so we're going to do just that. The business trust will legally disperse the $200,000 to its beneficiary, which is the family trust. Now your business just zeroed out. You had $200,000 in profit that was legally dispersed on a K1 from the LLC to the business trust, and then it was dispersed from the business trust to the family trust on a 1041 K1. So now your family trust has taken in this $200,000 as income from the business trust. The family trust can take all of its legal and lawful deductions as well. So for round numbers sake, we're going to say that the family trust has $100,000 in deductions throughout the course of the year, which still leaves $100,000 in taxable liability. The family trust can then make a 100% tax deductible charitable gift to your own private family foundation of $100,000. So that means the family trust had $200,000 in income, $100,000 in expenses. That last $100,000 was a 100% tax deductible charitable gift, which leaves zero, which means now the family trust has just zeroed out and there's nothing left to tax. Now, the private family foundation has one major obligation, and that is it must disperse 5% of what it brings in each year to a charitable organization. That could be the Boys and Girls Club, the March of Dimes, the American Heart Association, a university, a hospital. It doesn't matter where you're sending it. It's not going to the IRS. In this scenario, 5% would be $5,000. The other $95,000 is tucked away in a tax-exempt entity that can invest in anything that is legal and lawful and grow money tax-free legally. We just took $500,000 gross income, $200,000 of which was taxable, and you legally let go of $5,000. Now, what we're going to do is we're going to transition into looking at how we can do what we do and what the law has to say. Okay, guys, this is where we get into the interactive part of this presentation. I'm going to have you looking some things up because as we get into this public versus private information, I want you to understand there's nothing really private. Everything we're going to talk about today is public record. It's just that one set of information is readily available. The other set is kept secret. It's just not talked about, and it's definitely not taught. So let's get into this information. We're going to examine it. And then it's going to be up to you to determine what set of information makes more sense. So when looking to start a business, people will often look around to see what's the best type of business structure for them to have, right? So this is the public information, and most people will generally just go to Google and type in business structures or business organizations, and this is one I do want you to Google. I live in Texas, so this is just a website here in Texas. But I want you to Google selecting a business organization. It doesn't matter what state you're in. You're going to get the same options. a sole proprietorship, a general partnership, a corporation, S corp, C corps, and then at the bottom down there LLCs, and that's the general gist of the public information as to what entities you can operate from. Now, I just mentioned a business trust, but that is not on this list. As we go through this, I want you to keep that in mind. Wherever you live, what state you're in, if you Google this information, a business trust is not going to pop up in your Google search. But please do look in the state where you're at. The second place that people will generally go to look up what kind of business structures are okay or what they should or shouldn't have is the IRS website. So I want to take you there to this page on the IRS website, and I do want you to either pause this video right now and take this note: abusive trust, tax evasion schemes, special types of trust, or simply just pause this video right now and go to that page and read along with me. It's 2 pages worth of things, entities that the IRS deems as being abusive, right? So I'm going to point out 3 of these, and the first one on the list is a common law trust. So let's read what they say. Contrary to the claims of promoters, common law trusts no longer exist since all states now have statutes relating to the creation and operation of trust. So let's go back and unpack that. Contrary to the claims of promoters, common law trusts no longer exist. The word no longer suggests that once upon a time, common law trusts did exist. And then it goes on to say, since all states now have statutes relating to the creation and operation of trust. So this trust that used to exist does not exist anymore because of the states and state law or state statutes relating to the creation and operation of trust. Understand that, because we're going to examine all of this in the light of legal precedents. Common law trusts don't exist anymore because of state law is what they're suggesting there. Okay, here are the other 2 entities that I wanted to examine on the IRS.gov website. Abusive trust, tax evasion schemes, special types of trust. A business trust, which we just discussed, and a pure trust. So let's read these 2 terms. Business trust. The term business trust is not used in the Internal Revenue Code. The regulations require that trust operating a trade or a business be treated as a corporation, a partnership, or a sole proprietorship if the grantor, beneficiary, or fiduciary materially participates in the operations or daily management of the business. If the grantor maintains control of the trust, then grantor trust rules will apply. Otherwise, the trust will be treated as a simple or complex trust depending on the trust instrument. Now, let's unpack that one. Business trust, the first sentence. The term business trust is not used in the Internal Revenue Code. How does that make it abusive? If I say the Joneses don't exist in the Grant household, that is my home, that is a fact. They don't exist here, but that don't mean the Joneses are abusive. Let's continue. The regulations require that a trust operating a trade or a business be treated as a corporation. So the term business trust doesn't exist, but then they turn around and say that a trust can operate a trade or a business, right? Then they go on to say that it will be treated as a corporation, a partnership, or a sole proprietorship. Keep that in mind. They are saying that if a trust runs a business, it's going to be treated like all of those public entities we looked up on Google. Okay? Then it goes on to say if the grantor or beneficiary materially participates in the operations or daily management of the business, that's irrelevant. Here's something that we're going to talk about. If the grantor maintains control of the trust, that's a grantor trust, then the grantor trust rules will apply. We'll talk about that later. Otherwise, the trust would be treated as a simple or complex trust, depending on the trust instrument, which is your trust contract. All right. Now, let's take a look at pure trust. It says the term pure trust is not used in the Internal Revenue Code. Whenever the name of the arrangement, however, the taxation of the entity must comply with the requirements of the Internal Revenue Code. The requirements are based on the economic reality of the arrangement, not its nomenclature. If the pure trust meets the definition of a trust, then it would be taxed under simple, complex, or grantor trust rules, once again, depending on the trust instrument. So let's unpack that one. The term pure trust is not in the Internal Revenue Code. Just because it's not used in their code does not make it abusive. We saw that with business trust. Says whatever the name of the arrangement, however the taxation of the entity must comply with requirements of the Internal Revenue Code. It says whatever the name of the arrangement, right? It must comply with the requirements of the Internal Revenue Code. The requirements are based on the economic reality of the arrangement, not its nomenclature. So what all that means is you can call a trust anything you want to. There's over 80 different types of trusts. So you can call it whatever you want to. There's only 3 ways a trust is going to be taxed, period. And the document, the economic reality of the arrangement is the trust document itself, not the name of the trust, but how it's structured. The last sentence says, if the pure trust meets the definition of a trust, then it would be taxed under simple, complex, or grantor trust rules, depending on the trust instrument. Now, here's what I want to point out before we examine simple, complex, or grantor trust rules. You see these 3 definitions, common law trust, business trust, pure trust, are listed on the abusive trust tax evasion scheme special types of trust page on the IRS website. Have you seen a reference to anything that says why they're abusive? Any IRS code, and this is why I want you to go there, so I want you to go back and examine these things for yourself. Do you see a code or a law that says why these things are abusive? It's not there. These are words on a web page with no justification as to the validity of the words on the web page, which is why we're going to examine that other set of information, and we're going to do that here right now. But first, we're going to talk about simple, complex, or grantor trust rules depending on the trust instrument. Okay, folks, so there's only 3 ways a trust can be taxed. When they talk about grantor trust, simple trust, or complex trust rules, there's only 3 ways a trust can be taxed. It does not matter what you call the trust. It's the economic reality of the trust, which is the trust instrument. So here are the 3 ways. Grantor trust. All taxes are the responsibility of the creator. We're going to talk in pretty good detail about grantor trust, so I'm going to leave that alone for now. Simple trust. All taxable income has to be dispersed out to the beneficiary, and the beneficiary is responsible for the tax bill. This means that this particular trust cannot pay taxes on its own. It has to push all the money out. Okay? The last is a complex trust. And this is where either the trust itself can pay taxes on the income, or taxable income can be dispersed to the beneficiary. This is the trust that we're going to talk about today. And at the bottom there, it says only a complex trust can give 100% of its income to charity. That is going to be critical as we move forward and we get into talking about this other set of information. Now, guys, in the beginning, I told you that this is not new or novel, and it's not going to need to be litigated because it's already been litigated, right? So we're going to take a deep dive into some legal precedents, but I want to start off with this particular article from the Denver Post that says IRS chief apologizes to taxpayers. This is in 1997. I'm sharing this with you so that you can just let your hair down after this and take in the information, because this is very interesting. Okay, so that article is from a court case out of the 10th Circuit Court in Colorado. And during the course of this situation, this legal situation, there were some things that were brought out. One of the things that were brought out was the handbook for special agents for the IRS. And this section reads as such: avoidance of taxes is not a criminal offense. Any attempt to reduce, avoid, minimize, or alleviate taxes by legitimate means is permissible. So let's unpack that. Avoidance of taxes is not a criminal offense. Any attempt to reduce, avoid, minimize, alleviate, or alleviate taxes by legitimate means is permissible. So avoidance is not illegal. Evasion is illegal. Not filing taxes and evading taxes is illegal. Avoidance is not a criminal offense in their handbook. But it goes on to say any attempt to reduce, so reducing, avoiding, minimizing, or what does it say? Or alleviate. Any attempt to alleviate taxes by legitimate means is permissible. So what that is telling me is there's legitimate means to do all of the above. To reduce, to avoid, to minimize, or potentially even alleviate taxes by legitimate means. There's a legitimate way that that can be done. Okay, here's something else that was in that article that came out during this situation in 1997. In that court case, the judge brought up a previously decided court case called Edwards versus the Commissioner from the 10th Circuit in 1969. And here's what the judge said. A pure trust is not illegal if formed for the express purpose of avoiding taxes. I'm going to read that again. A pure trust is not illegal if formed for the express purpose of avoiding taxes. Now let's pause for a second. The IRS said the term pure trust is not used in the Internal Revenue Code, but it's being used in a court case. It's being referenced back to 1969 in a court case because this has been litigated. And it says it is not illegal if formed for the express purpose. The whole reason that this trust exists is for avoiding taxes. But on the IRS webpage, they said that this is abusive, that the pure trust is an abusive trust, special type of trust, tax evasion scheme. Tax evasion scheme. This says avoiding. Their own handbook says to avoid taxes is not illegal, and you can do so by legitimate means. So I shared this with you so again, you can let your hair down a little bit. And let's get into the other side of this information, which I reference as private, but none of this is private. All of it is public record. And you'll be able to look it up and do due diligence on your own if you like. And some of it's going to be interactive on this training that we're having. So as we move into this other set of information that we call private, that's not necessarily private. If there's nothing else you take away from this, I need y'all to understand the two most powerful tools in business. And that is a contract and the proper jurisdiction of law. When you marry those two, you create an entity that is bulletproof. So let's take a look at the definition of a trust. A trust is a three-party contract in which one can create a binding, inviolate entity. The creator is able to specify the terms, provisions, and who the other parties are. So let's examine this. A three-party contract. The three parties are the creator, the trustee, and the beneficiary. If you have these three separate, distinct parties, then you create a true trust contract, which becomes a binding, inviolate entity. You cannot penetrate it, and it is viewed as a separate legal entity. By IRS definition, it is a separate legal taxable person, right? That is the value of a contract. It separates things from you. Now, if you have what most attorneys put together today is a grantor trust or a living trust, here's how that looks. The creator is also the trustee, and then they typically will pick a loved one as a beneficiary. Well, that violates the definition of a trust contract. You have two parties, but three positions, because one person is fulfilling two roles as the creator and the trustee. Here's what that looks like in a practical sense. If you go out, you have a properly structured trust contract, and you have all your assets in the trust, and you go out and you have an accident that is your fault, and somebody gets hurt, or God forbid somebody perishes, and there's a lawsuit that's brought. When you go to the courthouse, the judge is going to say, well, Mr. Jones doesn't own anything. I'm not sure what you want me to do here. They're going to say, well, we understand he has a trust. We want the assets in the trust. The judge is going to look at that trust and say, this is a separate legal entity. This is a trust contract that creates a separate legal entity. Mr. Jones doesn't own that stuff, so I can't give you anything from the trust. That's how that's going to play out. Going back to a grantor trust or this living trust, here's what it would look like, same scenario. Going to court, they want to sue, he don't own anything, it's all in the trust. The judge is going to look at the trust and say, okay, this is a trust agreement, not a trust contract, which means that this is not a separate legal entity. This is an alter ego, and you still own all of that stuff. And I want to tie that back into what it said in business trust on the IRS website. Towards the end, it says, if the grantor maintains control of the trust, then grantor trust rules will apply. And that's what we're talking about. Control. Rockefeller said you want to control things without owning things. If the creator is also the trustee, everything still lies on the creator. You still own it. All of the tax liability, everything lands on you. A grantor trust is good for probate. It will definitely get you around probate, but there's no asset protection capabilities. So getting the trust contract right is extremely critical. So what does the Constitution say about a contract? In Article 1, Section 10 of the United States Constitution, it states in part that no state shall pass any law impairing the obligations of contracts. What that means is none of the people we vote into office in any state in this country as a collective, they cannot pass a law that can hinder a contract. Whatever's in that contract cannot be affected by laws passed by legislative bodies. So what do the courts have to say about contracts? Courts, however, must enforce contracts as made, not make new ones for the parties, no matter how unreasonable the terms may appear. They must enforce the contracts as they are written, and they can't make new ones for either party, no matter how unreasonable the terms may appear. And we've all seen this. If you watch any of the judge shows, Judge Judy, Judge Joe Brown, whoever, right? When the parties come in, the judge always asks one side to tell their side of the story, then the other side of the story, they'll listen to the other side of the story, and the first thing out of the judge's mouth is, do you have a contract? And this is why. Courts must enforce contracts as made, not make new ones for the parties, no matter how unreasonable the terms may appear. So if the Constitution says that the people we put into office to make laws cannot pass a law that can impair the contract, and the courts say that courts must enforce contracts, then for all intents and purposes, this trust contract is, to in some degree, creating law. So as you can see, based on the Constitution and legal precedents, a contract all by itself should be pretty much bulletproof. But the problem here we have in America is we have judges all over the country who want to legislate from the bench, who don't necessarily follow the Constitution or even legal precedent. But when you have a state judge, that judge is the authority for the state, and you're not always going to get an appeal. So placing this contract in the proper jurisdiction is what makes it bulletproof. And most people don't understand that there are 3 different jurisdictions of law that we can operate in America. The first is admiralty law. That's military law. Nobody wants to operate there because you really don't have any rights. The second is statutory law. That's state law. And most of us have been taught and believe that we have to operate by the laws of the state that we live in, and that's not necessarily true when it comes to business. The third is the English common law. When I say common law, I'm not talking about common law like common law marriages. I'm talking English common law. The Constitution itself was written under English common law, and the common law existed before there were any states. The true law of the land of America is the English common law, except for Louisiana, which was originally owned by the French. And to this day, the true law of the land in Louisiana is Napoleonic law. And for clients in the Louisiana area, they need to have an address outside of Louisiana for that very reason. But the common law is what the country is founded on. It's what the federal government is based on. And it is not changing across the country. It is universal. So we're going to take a look at some court cases to get an understanding of the contract and the proper jurisdiction of law and what the courts have had to say about this. A trust organization consisting of a U.S. constitutional right of contract cannot be abridged. The agreement, when executed, becomes a federal organization and not under any of the laws passed by any of the several legislators, Crocker versus McClay. Let's break this down. A trust organization consisting of a U.S. constitutional right of contract. We said the U.S. Constitution was written under English common law. So a trust organization written under English common law right of contract cannot be abridged. Cannot be abridged means you can't penetrate it. It's kind of like the definition of a trust as a binding inviolate entity. Cannot be abridged. That language says you can't penetrate this thing. It goes on to say the agreement, when executed, becomes a federal organization and not under any of the laws passed by any of the several legislatures. What that means is we operate above state law. We are not registered on the state level. And if there were any type of legal issues, because you can be sued in a trust as well, if there was any type of legal issues, that's got to be heard in a federal courtroom because this is not a statutory entity. It's not an LLC. It's not an S Corp, C Corp, general partnership. It's none of that. We don't get permission to exist from them. So this is a federal organization which has to be dealt with at the federal level. Now, the last case didn't specifically say common law trust. It says a trust operating on the U.S. constitutional right of contract, right? So let's examine a few more cases to make this really clear. Elliott versus Freeman, Crocker versus Malloy says a business trust is a common law entity formed by contract. I'm going to stop right there. Business trust was on the list of abusive things on the IRS website. It says that term does not exist in the IRS, in the Internal Revenue Code, right? Then common law trust, that was actually the first thing on the website of abusive trust tax evasion schemes, was a common law trust. And they said that entity no longer exists, right? I'm going to reread some of what business trust said. It said, the term business trust is not used in the Internal Revenue Code. Now, then it goes on to say, the regulations require that that trusts operating a trade or a business be treated as a corporation, a partnership, or a sole proprietorship. So let's finish reading the rest of this case. A business trust is a common law entity formed by contract and thus is not subject to the same types of regulations as a corporation. That is diametrically opposed to what the IRS put on that website. But like I asked you before, was there any legal reference or a reference to an Internal Revenue Code to suggest that it is abusive? Because here's the court saying it cannot be treated the way that they say it will be treated. Ashworth versus Hagen's estate says one of the main objectives of a trust contract is to obtain most of the advantages of corporations, but with freedom from the burdens, restrictions, and regulations generally imposed upon them. Didn't the IRS tell us that it'll be treated just like a corporation, a sole proprietorship, or a partnership? Okay, one more case real quick, and there are several references for this case underneath, but it says a business trust may be organized to engage in any business in which individuals or corporations may lawfully engage. Now, the question is, when we Google how to structure a business, why doesn't this term business trust come up? When we go to the IRS webpage, remember, this is that public information. Why do they tell us that this term doesn't exist in their code? It's all over different legal precedents, right? This is why I say it's private. Not that it's private, it's just not talked about, so we don't know what questions to ask. Now, people often ask me, Roger, how old are these court cases? Maybe these cases are a little outdated and what's on the IRS webpage is a little more up to date. So we're going to take a look at this. We're going to take a little journey, about 100-year journey, and examine that. This section of our training is called the Miseducation of America. We're going to talk about this nation's first private family foundations that ever existed. And we're also going to discuss why your CPA attorney probably doesn't know this information, because they don't know what they don't know. But it's not anybody's fault. It's by design. Because if our financial professionals don't have this information, then it's going to be extremely difficult for us to get it. The document on your screen is titled the General Education Board and Friends. And it is titled that simply because it's an investigation into the United States Board of Education, which John D. Rockefeller started himself. And Congress allowed him to do that. And then Congress had to come back 10 years later and do an investigation into to Rockefeller and Carnegie and these other corporate families and what they actually allowed them to do in establishing the Board of Education. So here's the little backdrop. John Rockefeller was a brilliant man, and he understood that if he could control the institutions that put out information, and if he could control the curriculum of those institutions, then the outcomes would be absolutely predictable. And he can control a whole country through the education system, which is why he created the Board of Education. In terms of institutions, amongst the black communities, our HBCUs are beloved, right? And we think that that is generally, black-owned colleges and universities are something that we have put together. Just for an example, Rockefeller's pastor's last name was Morehouse, and his wife's name is Spellman. Things you can look up. So things that we think are us was literally Rockefeller instituting institutions that would create predictable outcomes in our communities. As far as curriculum goes, the reason we learned the Dewey Decimal System in America is simply because John Dewey and John Rockefeller were friends, and Rockefeller wanted the Dewey Decimal System taught. He is still controlling that curriculum from the grave today. So we're going to read a little bit on the screen. You have 3 highlighted sections. I'm going to go to the second highlighted section on the right, and we're going to start at the first paragraph to give you an idea of the relationship between Rockefeller and Dewey. It says, in 1919, using Rockefeller money, John Dewey, by now a professor at Columbia Teachers College, an institution heavily endowed by Rockefeller, founded the Progressive Education Association. Through its existence, it spread the philosophy which undergirds welfare capitalism, that the bulk of the population is biologically childlike, requiring lifelong care. Let's go through that again. In 1919, using Rockefeller money, John Dewey, who was a professor at Columbia Teachers College, an institution heavily endowed by Rockefeller, founded the PEA, the Progressive Education Association. It had one purpose. Through its existence, it spread a philosophy. This philosophy undergirds welfare capitalism, that the bulk of the population is biologically childlike, requiring lifelong care. That's you and me. It goes on to say in the next paragraph, from the start, Dewey was joined by other Columbia professors who made no secret that the objective of the PEA project was to use the educational system as a tool to accomplish political goals. Yes, they were using the Board of Education to accomplish political goals. Now, we're going to go back to the first highlighted portion on the left-hand side of the screen and read a little bit of what this looks like. It says, the rise of foundations to key positions in educational policy formation amounted to what Clarence Carrier called the development of a fourth branch of government, one that effectively represented the interest of American corporate wealth. The corporate foundation is mainly a 20th century phenomenon, growing from 21 specimens of the breed in 1900 to approximately 50,000 in 1990. So I'm going to pause right there. What they're telling you is these entities that they operate from, the Ford Foundation, the Carnegie Foundation, the Rockefeller Foundation, there was only 21 of them in 1900. In 1990, there were 50,000. There's like less than 150,000 in the country now, I do believe. Let's continue. It says, from the beginning, foundations aimed squarely at educational policy formation. Rockefeller's General Education Board obtained an incorporating act from Congress in 1903 and immediately began to organize schooling in the South, which is where most of our HBCUs are. Joining the older Slater cotton woolen manufacturing interest and Peabody banking interest in a coalition in which Rockefeller picked up many of the bills. From the start, the GEB had a mission. A letter from John D. Rockefeller Sr. specified that his gifts were to be used to promote a comprehensive system. You might well ask what interest the system was designed to promote, but you would be asking the wrong question. Frederick Gates, the Baptist minister hired to disperse Rockefeller largesse, gave a terse explanation when he said the key word is system. American life was too unsystematic to suit corporate genius. Rockefeller's foundation was about systematizing us biologically childlike people, right? So it goes on to say, in 1913, the 62nd Congress created a commission to investigate the role of these new foundations of Carnegie, Rockefeller, and of other corporate families. After a year of testimony, it concluded, the domination of men in whose hands the final control a large part of American industry rests is not limited to their employees, but is being rapidly extended to control the education and social services of the nation. Let's unpack that paragraph real quick. The domination of men in whose hands the final control a large part of American industry rests is not limited to their employees. We know that the game of monopoly was created because these guys were truly monopolizing everything. So Congress knew that. But they said it's not just limited to that. They said, but it is being rapidly extended to control the education and social services of the nation. Y'all understand this is the federal government? This is Congress saying they're rapidly taking over our job. That's Congress' job. Social services and education. That's the government's job. Okay? It goes on to say, foundation grants directly enhance the interests of the corporation sponsoring them, it found. The conclusion of this congressional commission, the giant foundation exercises enormous power through direct use of its funds free of any statutory entanglements so they can be directed precisely to the levers of a situation. This power, however, is substantially increased by building collateral alliances which insulate it from criticism and scrutiny. I'm going to go back to one part. It says free of any statutory entanglements. The Giant Foundation exercises enormous power through direct use of its funds, free of any statutory entanglements. If they're not caught up in statutory entanglements and they're not operating under statutory law, then we have to ask ourselves, what laws are they operating under? We know they're not operating under admiralty law, because that is a place you don't want to be. You don't have any freedom under military law. So statutory law would include Congress. States create state statutes. Congress creates federal statutes. They're saying they're operating free of any statutory entanglements. That would suggest that they have to be operating under that third jurisdiction of law, the common law. Okay, so I told you guys that sometimes people ask, how old are the court cases that I shared with you, and how relevant are they today in comparison to what is currently on the IRS webpage? And I told you we're going to take a little bit of a 100-year journey, right? So the document we just looked at, the General Education Board and Friends, was based around 1903, 1913, that time frame, right? What we're looking at on the screen now is an article, and the date of this article is Monday, June 13th, 2011. That's that 100-year time frame I was telling you about. So we bring this forward to 100 years, and this is just a little over a decade ago. And this is a court case that says Supreme Court rules no fiduciary exception in trust between U.S. and Native Americans. So I'm going to give you the backdrop, and then we're going to read the highlighted parts. So the Apache Indians in this country had some assets that were being held in trust by the federal government. The federal government was the trustee. The Apache Indians, as the beneficiary, felt as though the government was misappropriating their funds. They said, we need you to open up the books and show us what you're doing with the corpus of the trust. And this is how the court responded to the Apache Indians. In the first highlighted portion, it says, the opinion of the court by Justice Samuel Alito reasoned that the government acting as a trustee is unlike a trustee in a private trust created at common law, because the government is acting within statutory authority granted to it by Congress. So let's back up. Let's unpack that real quick. The opinion of the court by Justice Samuel Alito, who is still sitting on the bench today, reasoned that the government acting as a trustee is unlike a trustee in a private trust created at common law. I thought common law trust no longer existed. That's what was on the IRS page. It's still there today. This case is just a decade old. So this is no different than those other court cases. It just has a more current date on it. But this is a Supreme Court justice referencing a private trust created at common law. And why is it? Where's the difference? It says, because the government is acting within a statutory authority granted to it by Congress. Is that or is that not a distinction between two different trusts and two different jurisdictions of law? It absolutely is a distinction made by a sitting justice sitting on the bench right now, just about 10 years ago. Now, that's not the kicker. If we scroll down to the bottom, the third line from the bottom down there says, Justice Sonia Sotomayor was the lone dissent, arguing that the government is fulfilling the traditional fiduciary role as a trustee for the benefit of the tribe. Further, she argued that the exception should exist since Rule 501 of the Federal Rules of Evidence text says that the government's privilege is to be informed by the common law. It is the federal government's privilege to be informed by the common law. Why? Because our Constitution was written under English common law. It informs everything the federal government does. So we have two different justices talking about two different trusts and two different jurisdictions of law. But what we're going to take away from this as we move forward, I'm going to reread something Samuel Alito said so we can dive into it a little bit. He said, the government acting as a trustee is unlike a trustee in a private trust created at common law. What exactly did Justice Samuel Alito mean when he said a private trust created at common law? Okay, from this point forward, we are going to focus on privacy, what Samuel Alito mentioned, and the power of the contract. So what did Samuel Alito mean? This case here, Smith versus Morris, says the records of the trust are confidential and their books and records are not subject to review or subpoena. Let me back up and read that again. The records of the trust are confidential and their books and records are not subject to review or subpoena. What's an IRS audit? Is that or is that not a review of your financial documents to determine whether you have some tax liability or not? What is a subpoena? That is where the courts force you to turn over paperwork for the courts to examine. So I'm going to read this one more time. The records of the trust are confidential and their books and records are not subject to review or subpoena. Smith versus Morris. Before we dive in a little bit deeper on the privacy and power of the contract, I want to share with you guys some definitions from the IRS themselves on statutory law versus common law. Okay, we're going to start at the top of this page and read these definitions, and then we're going to read that highlighted portion at the end as a bonus. The IRS makes this distinction between the two kinds of law. Common law comprises the body of principles, the rules of actions relating to government and security of persons and property, which derive their authority solely from usages, customs, or from judgments and decrees of courts, recognizing, affirming, and enforcing such usages and customs. Folks, what they're telling you is the common law has some history to it. There's precedence to it. There's something behind it to make it valid and legitimate. Here's their definition of statutory law. Refers to laws enacted and established by a legislative body. That's the whole definition. So what they're saying is, you and I vote people into office. They get into office. They say, hey, this sounds like a good idea. Let's pass and make it a law. There's no history. As it says in the common law, it says relating to government and security of persons or property, which derive their authority solely from usages and customs. There's history. And it derives authority, it says, or from judgments and decrees of courts, recognizing, affirming, and enforcing such usages and customs. There's a history. The common law is meaty. The statutory law is something they say sounds like a good idea. Let's make it happen. That's the difference between the two. Now down here at the bottom, it says the tax court is a statutory court of limited jurisdiction and strict compliance with all essential jurisdictional elements is necessary before the court is empowered to enter a legal decision in the case. You can screenshot that, pause it, Google those numbers at the bottom down there, and pull that up and read it for yourself. It's on their website. So what it's saying is the court has a limited jurisdiction. Limited jurisdiction means there's some places you just can't go. I read that to you because we just read Smith versus Morris. And we're going to finish this thing off with the most powerful court case in United States court history, just so you can get an idea of what limited jurisdiction looks like. So here's where the IRS tells you the power of your contract. Title 26 of the Code, Section 61, reads as such. Gross income means all income from whatever source derived, including but not limited to the following items: income from an interest in an estate or trust. IRS states that fiduciary accounting income is the amount of income determined under the local law or the specific terms of the governing instrument. Now, the governing instrument is your trust contract. The contract governs, not anybody outside. So let's read that again. The IRS states fiduciary accounting income is the amount of income determined under local law or the specific terms of the governing instrument. Does that or does that not put you on par with the law? Right? Local law puts you on par with the local law. But here's the deal. If you pick your jurisdiction properly, you're going to be in a common law jurisdiction. There is no local law because this is a federal organization. As you get a little bit deeper into Title 26, we're going to look at Section 643B. It says income is determined under the terms of the governing instrument. Now, what we're going to do is we're going to go look at Section 643B. This is one of those interactive parts of this training, and I need you guys to see that all of this information is at your fingertips, and documentation beats conversation all day, every day, and twice on Sunday. So let's take a look at this next slide, and I want you to pull up this Google screen. Okay, guys, so this is a simple Google search. Here's what you need to put in the search bar. IRC 26, Section 643B, right? And it should come up looking just like this. And the second link, hopefully when you pull it up, will be that link down there that says www.law.cornell.edu. And then you're going to click on that link and just scroll down to where it says Section B. And I'm going to pull up Section B in the next slide for you so that we can read it together. But I want you to have it on your own computer so you can go back and read it again, because it's a little bit of legalese in this, and I want you to go back and process it for yourself after we go through it. Okay, if the Google search went well and you got into Cornell Law and scrolled down to Section B, which is called income, which is what we were talking about, income for the trust, then this is what you should be looking at. So let's read it through, and then I'll break it down in layman's terms so you can see how powerful your contract actually is. It says, for purposes of this subpart and subparts B, C, and D, the term income, when not preceded by the words taxable, distributable net, undistributable net, or gross, means the amount of income of the estate or trust for the taxable year determined under the terms of the governing instrument and applicable local law. Items of gross income constituting extraordinary dividends or taxable stock dividends, which the fiduciary acting in good faith determines to be allocable to corpus under the terms of the governing instrument and applicable local law, shall not be considered income. So let's break this down. There's a lot of legalese. Let's make it simple. The first part. For the purposes of this subpart, B, C, and D, the term income when not preceded by taxable, distributable, all of that we're going to leave alone. This says the amount of income under the estate or trust for the taxable year determined under the terms of the governing instrument. Means the amount of income of the estate or trust for the taxable year determined under the terms of the governing instrument and applicable local law. But because we're a common law trust and this is a federal organization, not a statutory organization, there is no local law. So it's telling you that income itself is determined under the governing instrument. Then it goes on to say, in terms of the governing applicable law, and it says items of gross income constituting extraordinary dividends or taxable stock dividends. That means a large amount of income, even if it's taxable stock dividend income. It says which the fiduciary is the trustee, the person in control, which the fiduciary acting in good faith determines to be allocable to corpus under the terms of the governing instrument, and applicable local laws shall not be considered income. So let's simplify that. It says if you have items of gross income constituting extraordinary dividends, big bucks, or taxable stock dividends, which the trustee acting in good faith determines to be allocable to corpus, that means it's an asset, it's not income. It says under the terms of the governing instrument and applicable local law, then it shall not be considered income. So what they just told you is if you have massive amounts of income come in, the trustee acting in good faith determines it to be a part of the corpus of the trust and not income under the governing instrument, then it shall not be considered income. Point blank, period. Now, I wanted you guys to have that on a Google screen so you can process through it, chew on it a little bit, come back and listen to this portion of the explanation in this training. It is telling you that your contract determines what is income and what is not. And that's from the IRS, given to you by Cornell Law School. That's not something Roger wrote. That's not something Roger said. That's just something Roger's sharing with you that's right there at your fingertips. Okay, so now let's transition from the IRS to the federal government and look at the Uniform Trust Code so you can see how powerful your contract is. The Uniform Trust Code is a federal statute handed down by the federal government to the states on how to deal with trust. I want you to hear the first sentence of the Uniform Trust Code. It says the Uniform Trust Code is primarily a default statute. Most of the code's provisions can be overridden in the terms of the trust. Most of the code's provisions can be overridden by your contract. That's how it starts out. Interesting, right? So let's scroll down to the next highlighted section, which reads this. Section 106 and 107 focus on the sources of law that will govern a trust. Section 106 clarifies that despite the code's comprehensive scope, not all aspects of the law of trust have been codified. The Uniform Trust Code is supplemented by the common law of trust and principles of equity. Section 107 addresses the selection of the jurisdictions or jurisdictions whose laws will govern the trust. A settlor, absent overriding public policy concerns, is free to select the law that will determine the meaning and effect of trust terms. You can pick your jurisdiction, but I want to focus on this part, that check mark. It says the Uniform Trust Code is supplemented by the common law of trust and principles of equity. Didn't the IRS tell us that common law trust no longer exists? Then why is this language inside of a federal statute that still exists today? But I also want to tie this to what Sonia Sotomayor said. She said it's the government's privilege to be informed by the common law. And I told you everything on the federal level is informed by the common law. So this makes sense. The Uniform Trust Code is supplemented by the common law of trust and the principles of equity, because that's how things work at the federal level. Everything is about common law. So you guys get to choose to operate in that jurisdiction of common law, because it tells you get to determine what law will determine the meaning and effect of a trust terms. Here's one more section of the Uniform Trust Code before we move on to the most cited case in United States court history. It says, however, the Uniform Trust Code does not try to incorporate detailed rules for every conceivable kind of trust, nor does it incorporate all of the kinds of trust there are. It does not contain statutory rules that are already governing trust in many jurisdictions and that are working just fine. It does not displace, for example, the Uniform Prudent Investor Act or the Uniform Custodial Trust Act. What the Uniform Trust Code contains is a set of basic default rules that fairly, consistently, and clearly govern voluntary trust. It is a default statute for the most part because the terms of a trust instrument will govern, even if inconsistent with statutory rule. Now, I'm going to read that again, and I'm going to use trust contract so you guys can get the gist of it. This is a default statute for the most part because the terms of a trust contract will govern even if inconsistent with statutory rule. It will override statute. That's why they call it the governing instrument. It is, as we mentioned in the beginning, something that the Constitution says lawmakers can't pass a law that can impair it, and courts must enforce it. So it is truly the governing instrument. And this next court case, I think, should make that very clear as we get ready to wrap this up. Hale versus Hinkle is the most cited court case in United States court history, and it speaks directly to what we've been talking about in this training. Here's a little backdrop to this case, a little explanation on what it's about. Your right to private contract. Hale versus Hinkle was decided in 1906 by the United States Supreme Court. Since it was the Supreme Court, the case is binding on all courts of the land until another Supreme Court case says it isn't. Has another Supreme Court case ever overturned Hale versus Hinkle? No. As a matter of fact, since 1906, Hale versus Hinkle has been cited by all of the federal and state appellate court systems over 1,600 times. Remember that in nearly every instance when a case is cited, it has an impact on the precedential authority of the cited case. The more times a case is held up as the law, the more it becomes cast in granite. Here's the opinion of the court. The individual may stand upon his constitutional right as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation, so far as it may tend to incriminate him. He owes no duty to the state since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land, common law, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. Okay, so let's touch on a couple things in here as we wrap this up. It says in the second line, he is entitled to carry on his private business in his own way. That's what Samuel Alito was referring to when he was dealing with the Apache Indians. He said this, you're confusing your situation with a private trust created at common law. Hale versus Hinkle is referring to that. Smith versus Morris says the records of the trust are not subject to review or subpoena. There's true privacy. Then it goes on to says he owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation. Remember when the IRS said it's a statutory court of limited jurisdiction? They can't treat us like they can a corporation. I'm going to read the last part here. It says, he owes no duty to the state since he receives nothing therefrom beyond the protection of his life and property. Here's the difference between this entity and any other business entity and that public record, the sole proprietors, the LLCs, the S Corps, the C Corps, all of those things, all of those entities, we have to get permission from the state to exist. We exist by contract and is private, and the Constitution protects contracts. The courts must enforce contracts. So they can't treat us like they can treat a corporation. That's why they can't subpoena the records. That's why they can't review the records. And that's why it is private. The privacy and the power of the contract is how we ended this presentation. And this court case speaks specifically to it, and it is the most powerful, most cited court case in United States court history. So here's a visual for you guys of the entire system. The business trust is where you earn and disperse. Family trust is where you manage and you donate. Your non-operating private family foundation is where you give. It's where you build your legacy tax-free. It's all legal and lawful, and it is there to position and protect and pass on your money to the next generation as you see fit without any outside interference. As we're moving through the system, the most critical part of the system is a proper contract. Contracts are critical. Placing that contract in the proper jurisdiction of law makes it bulletproof, but proper contracts are absolutely critical. As we wind this thing down, guys, I want to simplify it for you a little bit. I know we've talked about a lot of court cases, a lot of IRS stuff, and I want to simplify, make it easy. There are two things a complex trust can do that other trusts and corporations and a person cannot do. The first is they can give away 100% of their gross income to a beneficiary, passing on that tax liability to the beneficiary. The second thing is they can give away 100% of their gross income to charity if they choose to. Now let's take a look at that. These next two slides I pulled off the IRS website several years ago, and I haven't been able to find them since. So I'm glad that I saved them so I could share them with you. Let's read this. Taxation of a non-grantor trust. We know a grantor trust is going to be taxed to the creator. So let's read what it says. If the trust is not a sham and is not a grantor trust, the trust income reduced by amounts distributed to beneficiaries is taxable. I told you a complex trust can either pay the taxes or it can pass on tax liability to the beneficiaries. It goes on to say the trust must obtain a taxpayer ID, identification number, and file annual returns reporting its income. The trust must report distribution to beneficiaries on a K-1, and the beneficiary must include the distributed income on the beneficiary's tax return. Just want to touch real quick on that K-1. You remember when we were talking about an LLC earlier and how it would pass the profits on a K-1 to the owner of the company or to the business trust? That's called pass-through accounting. You're telling you here that you can do the exact same thing with this trust. Pass that liability on through a K-1 filing. It's just a 1041 K-1, and they don't put that on here. It just says Form K-1. Very interesting. But it's telling you guys that the first thing a trust can do is it can either pay the taxes or it can pass all tax liability to a beneficiary. Here's the second thing a trust can do that other entities and people cannot do. May a trust deduct contributions to a charity. A simple trust cannot. I told you guys that simple trusts have to pass all of the income to the beneficiaries and let them pay the taxes on it. So it can't give to charity. It has to give it away. A grantor trust cannot, because that's still owned by the owner, the creator. So there's limitations on how much a person can give to charity. Here's what it says though. A complex trust may, but the deduction must meet the rules similar to those for deductions by individuals, except for the percentage limitations, and be explicitly allowed in the trust instrument. Trusts that claim a charitable deduction generally also file a 1041. There's your 1041. 1041A. U.S. information return for trust accumulation of charitable amounts. In a grantor trust, the deduction would be attributable to the grantor and governed by IRC Section 170, charitable deductions. So let's be real clear. Let's talk. A simple trust can't give away. It just can't do that. A complex trust may, but the deduction must meet the rules similar to those deductions for individuals. But you see that in quotations? It says except for the percentage limitations. There is no percentage limitations. None. That's why they put that in quotes there. They tried to make it sound like it's going to be treated like an individual, but in quotes it says except for percentage limitations. And it says, and it must be explicitly allowed by the trust instrument, which is true. Okay, so trusts that claim a charitable deduction file a 1041 return for accumulation of charitable trust amounts. It says in a grantor trust, the deduction would be attributable to the grantor because you still own it. It's an alter ego. It's still you. And they have limitations. So a person can give 60% of their gross income to a regular charity, a regular nonprofit. They only allow an individual or person to give 30% to a private family foundation because they know we operate differently. But those are the restrictions that are placed on individuals. They put a cap on how much you can give away. You can't give it all away and literally write it all off. That's why it says except for the percentage limitations. A trust, complex trust, doesn't have any percentage limitations. If you want to give away 100% of your gross income, as a trust, you can give all of it to the foundation. So those are the two things a trust can do. To simplify all of what you heard today, it can pass through 100% of its income to a beneficiary, or it can pass through 100% of its income to a charity. And we're just simply using the rules laid down by the IRS and the courts to operate in the freedoms that we truly have in our right to private contract. So let's recap what we've covered in this training. We talked about how to reduce your taxes to 5% or less with full disclosure, filing all the proper tax paperwork. We talked about how to protect your assets from lawsuits, divorce, or any of life's unforeseen events that may cost you money. We've talked about how to leave a bulletproof inheritance and legacy without your loved ones paying probate and lawyer fees. Yes, we talked about how to eliminate potential for an IRS audit. And lastly, we talked about how the elite position, protect, and pass on their assets, and how you can too. It really does come down to two choices, guys, because there are two paths, because there are two different sets of information. Ultimately, for us to make an educated decision, we have to have all of the information, and that's not something they're going to give us readily or freely. I hope that today you got enough information so that you can really process which set of information makes more sense. What you can Google and what the IRS is telling you with no legal precedent, or all of the stuff that we dug out on the IRS webpage, plus all the legal precedent. You just got to decide which one makes more sense so you can effectively plan your financial future and ultimately your family's legacy. God bless you all.